bolts of filing a provisional patent application. Probably the main reason you're sitting here in these seats. What do you think of my sweater? Think it's long enough? You're probably thinking, couldn't he find one that went down to his knees when he was rummaging around the apartment this morning? It's not that often that we get snow in the middle of March, so I apologize for my appearance. Anyhow, today, like I said, what we're going to talk about is how to file a patent application. This is a long-standing problem for inventors. The patent office often acts as a barrier to your ability to monopolize and monetize your invention. Sometimes they can seem like an impenetrable bureaucracy that is more resistant to creating and granting intellectual property rights than perhaps they should be. When it comes to patent applications, I just want to quickly cover, because I got some questions from the class that showed that maybe I wasn't clear enough on the America Invents Act. Remember, we talked about this. This was the statute that was passed in 2011 and took effect on March 16th, 2013, which has to do with making the United States a first-to-file country. But as we talked about yesterday, it's not an absolute first-to-file country. It's kind of a sort of first-to-file country. And that's because of the grace period that we talked about. So as we said yesterday, we've long been a first-to-file or a first-to-invent country. This was, of course, the CRISPR decision that we talked about, which was so important to the CRISPR decision, which, of course, if it couldn't happen today, at least not the same way, because now we're first to file. But the first to invent all changed when President Obama passed or signed into law this legislation that was passed by Congress. And basically what it says is for patent applications with an effective filing date of March 16th, 2013 or later, the United States shifts to what is often and only partially accurately referred to as a first-to-file system. The reality is a little bit more complex, and this gets to the questions that I wanted to address that came to me after class, because patent rights in the United States under the first-to-file system will depend upon the interplay between the date of filing and any pre-filing disclosures. Remember, we were talking yesterday about the effect of publishing your invention in Nature or in other journals. That has an effect on your ability to file a patent application. And just to answer the questions I got directly, when you publish, that starts the clock ticking with respect to the 1 year you have to file a preliminary patent application. So long as you file within that 1 year period of time, you're okay. But it's important to remember that when you publish, the clock starts ticking. Not when you file the preliminary patent application, but when you publish, or when you disclose, or when you offer for sale. Any public dissemination of the information that describes your invention, that's when the clock starts to tick. So as we talked about yesterday, one of the things I always advise my clients is if you're going to publish, file the preliminary application the same day. There's no harm in that, and it really protects your backsides when it comes to others. And I'll give you some examples. This is what we've already talked about. We're not transformed into an absolute or a true first-to-file system. This is because the Congress, when they drafted the AIA, wanted to carve out some rights for people in universities like this who have, who basically do all the basic research that results in these things. And so what they did is they added this section, this grace period section, in order to accommodate researchers. And so accordingly, as I say, applicants must be cautious, as a delay in filing an application can result in the loss of patent rights. So let me tell you how this works, the interplay, and how it's a little complicated. So take the example of an employee in company A who conceives of an invention in May. And he works, or she works very diligently to reduce it to practice, and then files the application for the corresponding patent 3 months later in August. Okay? Suppose at the same time, an employee from another company independently conceives of the same invention a month after employee in company A, and files the application in July, so that, in other words, the employee in company B beats the employee in company A to the steps of the United States Patent Office. Under the old first to invent rule, company A gets the patent. So if this happened before 2013, company A would get the patent because that inventor conceived of it a month earlier. But how about under the AIA? Under the AIA, the result is more complicated. If company A doesn't make any disclosure before August, that is the filing date, they conceive of it in May, they file in August. So if they don't make any disclosures before the August filing, then company B gets the patent. Why? Because of its earlier filing date. They won the race to the steps of the USPTO. But if company A describes the invention in detail, publishes it in Nature, okay, or something like that, in a PhD thesis, publishes it anywhere, talks about selling it at a trade show, then in that case, company A gets the patent, even though company B beat them to the steps of the USPTO. Why? Because the disclosure starts the clock running. Okay. So it's kind of a double-edged sword. The disclosure can save your patent rights, but at the same time, it begins the clock ticking, so it means you have to act within 1 year. I had another example. Company A conceives of an invention on January 1st, 2013, which is before the effective date of the AIA. Company B independently conceives of the same invention on February 1st, 2013. Again, before the effective date of the statute. Company B publishes a detailed enabling disclosure of the invention on March 1st. Company A diligently files a patent application for the invention on April 1st. Who gets it? Exactly. As a result of B's publication of the disclosure for the invention before Company A's patent application filing, and since Company A's patent application was filed on or after March 16th, thereby falling within the effective date, only Company B has potential US patent rights. Okay, now in other countries, and we talked about that, Japan, China, certain European countries, Great Britain, the first to file wins, gets the patent rights. So while Company B may be able to have patent rights in the United States, they may have problems abroad. And in situations like this, what often happens is Company A and Company B get together and they decide to sort of share things. So oftentimes what happens is, you know, if you have an invention that has only application in the United States, you don't have to do this, but if you an invention that may have commercial potential around the world, you'll often get together with a competitor and share the intellectual property. It's always nice to consider resolving these things rather than litigating these things. And that's oftentimes what happens.
Imagine if you were in the second case, you could just modify your design slightly and patent that.
Well, you know, and we'll get to that. But remember, you've really got to put a lot of distance between the state of the art and your invention. We talked about, you know, novelty. You know, it has to be new, it has to be novel, it has to be original, it can't be non-obvious, and it has to be useful and operative. You know, that word new is a problem, and it just doesn't mean new like I thought of it. New means novel, it has to be a significant advance. It really has to be a step up in order for it to qualify to be statutory, to meet the novelty requirement. So, you know, as long as you can come up with something that represents an advance over the state of the art and prior art, in this case, your competitors filing, you know, you're okay. But that's a pretty high bar. The merits of first to file, and this is important for what we're going to be talking about. Yeah.
You talked about 1 year of time. The 1 year, I mean, within 1 year, you just need to file a preliminary patent application or the patent itself?
The preliminary. Just a preliminary. So from the date of publication, the clock starts ticking. And you know, the reason my advice to people is to file the preliminary is it's cheap and it's, you know, fast and and as we'll see, it's really pretty easy. It's, you know, it's not rocket science. It really isn't. Anyhow, the merits of first to file, who does it benefit? You know, big companies that have the resources, or maybe small companies that are, you know, that are more agile and can react more quickly. But the main inventors that benefit from this system are the people who file first. The downside, you know, of the first to file system is the pre-filing disclosures that weren't eliminated by the AIA can eliminate the ability to obtain rights in many international jurisdictions. We gave the example of, you know, where someone may have published, so they're okay when it comes to securing US rights. That can be a problem if you're marketing in China or Japan or Great Britain or Germany in jurisdictions that are absolute first to files. So when in doubt, file the preliminary patent application, period, end of story. There's always one solution, of course, to this first to file and the interplay between publication and filing the preliminary application. This inventor here, of course, has the best solution, which is to invent a time machine where you can pop in, see if there are any good ideas, and then go back in time and patent it. Exactly. Is anybody here old enough to remember Mr. Peabody's Wayback Machine? Okay, good. Yeah, I was going to put Mr. Peabody and Sherman up there, but I thought, you know, this is because I guess I'm getting too old. I'm trying to know my audience, but I was afraid to put Mr. Peabody and Sherman up there out of a concern that nobody here would know who Mr. Peabody and Sherman were. But Mr. Peabody was a dog who had a boy Sherman, and Mr. Peabody had a Wayback Machine, and Mr. Peabody the dog used to take Sherman back to significant events in history and show how it really, you know, how it really happened. Rocky and Bullwinkle? Nobody?
I have a question for you, Steve.
Is it on Rocky and Bullwinkle, or
It's on
something that I know, or this?
I guess it goes towards patents. So I was asked years ago by a company, they had some Department of Energy funding to review their quote-unquote invention, which was nothing more than a perpetual motion machine. They thought they could create energy by doing something which they couldn't. So is there, is the USPTO, you know, like automatically, I mean, they'll review it.
You know, I want to say a positive word about the USPTO. I think yesterday I talked about how the further up the food chain you get, the more likely the decision is going to be made by somebody that has absolutely no idea about intellectual property law, like Supreme Court Justice Clark, who was a wonderful Supreme Court justice, but his background was in criminal law, and these are the people that are writing the decisions. The people at the USPTO have really specialized expertise and skill. And quite frankly, looking back on my experience in intellectual property law, the people that know the most about intellectual property are at the USPTO. And they are really good at examining patents, and they have specialists in each area. So you have specialists in mechanical utility patents, you have specialists in design patents, you have specialists in, I don't know what it would be, but energy, okay. And they'd examine it. And if it met the statutory requirements, you know, it would get a patent, but it sounds like operativeness, okay. You remember, it not only has to be new and it has to be useful, but you have to demonstrate operativeness, would be like the downfall of that particular device. But it would get a fair hearing, so to speak. You know, of course, it depends on the filing, and we're going to get into that right now, but you know, the inventor would have to describe how this device works. And if the inventor fails to describe in the patent application adequately how that device works, the likelihood of it being approved is slim. So, how to file a provisional patent application. Okay. Since June of 1995, the USPTO has offered inventors the option of filing a preliminary patent application. And this provided, as I said, a low-cost, sort of streamlined, easy-to-do method of seeking patent protection in the United States. A provisional patent application or preliminary patent application is a lot simpler than a formal full patent application. And it can be done, as we're about to see, by almost anybody. In fact, certainly anybody in this class will have no problem doing it because there are people out there who have, you know, don't even have high school educations that can file provisional patent applications. The USPTO really came up with a user-friendly way of doing this. And one of the reasons why is because of the AIA. You know, if there's a lot of pressure on people to file first, you've got to make the system user-friendly or friendly to the inventor, because you don't want to have the first-to-file legislation act as a bar to intellectual property rights. Intellectual property rights need to be available. Remember, that it's in the Constitution of the United States. It's part of your being a citizen of this country. So, what is a provisional patent application? A provisional patent application is a type of interim utility patent filed with the USPTO. An application for provisional patent can be filed without including any formal patent claims, an oath or declaration, or any information concerning prior art. So it represents a much simpler form of a patent application. The key word is provisional. Provisional means you only have 1 year. So it's not like a patent application or a patent which, once it's granted, is 20 years for utility patents. The thing to remember is that a provisional only lasts 1 year. You have to convert it in that time to a full patent. So it's like the second ticking clock. You know, the first year, the clock starts ticking when you disclose. And once you file your provisional patent application, you have 1 year to convert it to a full-time or a full patent application. But that's good because it gets your foot in the door, it saves your place, and gives you as an inventor time to refine your invention and time to work on the full patent application. And so it's a tremendous strategic advantage. It makes it possible for you to protect your intellectual property rights while you pursue the process of finalizing your patent application.
Doesn't that give an advantage if you hold off on your provisional patent after you publish? It gives you 2 years.
Yes, yes, in the United States. But remember, the clock starts ticking as soon as you disclose. So if you have, aspirations of marketing in China or in Great Britain or in Germany, then you may be barred from obtaining those rights. In those countries, it would be considered, if after a certain period of time, it would be in the public domain. Or if somebody filed before you did in those countries, they would own the patent. So, yes and no.
Two questions. The first one, so in order to file a patent everywhere in the world, do you need to go physically there, or you can do everything through the USPTO?
No, you've got to go and actually file. So, however, other countries do recognize by treaty, filings in the United States. So there's a streamlined process in Great Britain and other countries, not so much in China, because TTP has, I keep coming back to that. We tried to make things homogenous with that, but we lost that opportunity. So what you've got to do is you've got to hire a law firm that specializes in IP in Great Britain and have them file. You've got to hire a law firm that specializes in IP in China and Japan and have them file. But if you're the owner of the patent, it's a streamlined process. So the only hard part about this is you're getting your patent application on file with the USPTO. As a practical matter, it's not that difficult. So long as you don't get disadvantaged by the interplay between absolute first-to-file jurisdictions and semi-first-to-file jurisdictions.
And the second question was, is the provisional patent application public or?
Yes. And once you file a provisional patent application, you can go on the USPTO website and you can actually see it. And there are publications. The USPTO has publishes these things. The idea is to be transparent. And as an inventor, you want this to be published because you want everybody to know that your invention is patent pending. So they need to respect your intellectual property rights. One of the reasons that you do a search of the prior art when you are filing a provisional is to determine whether anybody's beaten you there. So that's one of the essential steps in filing a preliminary application, patent application, is to do a search of the prior art to determine whether or not anybody has beaten you to the steps of the USPTO. Now, this gets to the ease of these provisional patent applications. There are no official USPTO forms available for provisional patent application. Parts of the application in fact, all of the application will need to be written by you on a blank sheet of paper. The only thing that the USPTO requires you to fill out is their cover sheet, which you can either do by paper or online. Everything else, though, is something that you have to come up with all on your own. So what do you need to include in a provisional patent application? Well, there are basically three things. First, you have to include a specification or description of the invention, which is just the written description of what it is that you have, you're seeking intellectual property protection for. Second thing that you absolutely must have are figures or simple drawings. I always advise people to, if they're not don't have mechanical drawing in their background, is to hire somebody to come up with some mechanical drawings or figures for your application. And that's very inexpensive, and you can upload the image from your computer when you file your application. And then the only other thing that you absolutely positively must have is the transmittal letter or cover sheet, which describes who the inventors are, where they live, so on, so forth and so on. So they know how to get a hold of you. It requires your name, your address, your email address, your phone number. As you can see, they're, in general, that's all that's required. So, a provisional patent application does not need to have claims or formal drawings. That would be absolutely essential to a formal patent application or a final patent application, but they're not required in a provisional. I, however, advise my clients to include at least one claim, and also formal drawings. Why? Because it shows that the patent examiner that your idea is sophisticated. It also gets you a leg up on the final patent application. And claims we'll talk about it in more detail, but claims are so important because remember we talked about the CRISPR case. They shot for the moon. The University of California at Berkeley made a claim that their gene editing techniques covered basically everything that gene editing can be applied to. Of course, they weren't able to demonstrate practical utility or the success of these claims that they were making, but they made the claims anyhow. And there's a strategic reason for that, because you want to control as much as you possibly can when it comes to the application of your invention. So you don't have to have drawings, you don't have to have claims, but I recommend that that you do. Obviously, that's one of the reasons why it's less expensive. Writing a claim section, by the way, is a bit of an art. We'll show you how to do it, but the more complicated your invention is, the more art and science there is in writing a claim section. And then, like I said, there's some debate among patent experts. I don't necessarily consider myself one, but as for me and the advice I give my clients, include claims and include drawings. Make it as much like a formal patent application as you can. Better chance of getting it approved, and the further along you'll be when it comes to 365 days later when you have to file the final.
You want to overclaim and then back off when you do the final, or underclaim?
What was that? There was a character on the show Taxi. I keep coming up with these old shows. Louis De Palma, and he was going to inherit some money at one point. All he had to do is determine how much to ask for, and he kept thinking to himself, "Well, should I ask for this much? No, that's too much. That's too much. And maybe I'll just ask for this. No, that's not enough." That's the same way it is with claims. My advice is to be honest about the claims section. This requires some thinking on your part. Let's say I'm inventing a peanut butter sandwich. Okay, let's just use that as an example. Well, how many versions of a peanut butter sandwich can I imagine? I can imagine a peanut butter sandwich with marshmallow fluff. I can imagine a peanut butter sandwich with jelly. I can imagine a peanut butter sandwich with lettuce and tomato. When I was a kid, we used to put potato chips in them. Those would all be separate claims, okay, for your peanut butter sandwich. So my advice is to think about the way your invention can be applied and describe it in terms of as many claims as you can come up with. because that will define the scope of your intellectual property protection. Okay?
Do you have to maintain that when you go to the final patent?
Yes. When you, well, like I said, claims are not required in a provisional, but this is the time to start thinking about it. And there's nobody that says you can't file claims with a provisional. And I think it's a good idea, because think of the examiner. The examiner gets this piece of paper on their desk, they're looking at it. The first question they ask is, what does it do? What are they claiming that this can do? And this is a great way of getting a leg up on your final patent application and describing it for the claims examiner in such a way that it's clear and concise. This is the specification section. So you have to have a title for the invention, peanut butter sandwich, okay? The background of the invention, so describe the technology of the invention, what problems there are that the invention is designed to address or solve. The technology area is food or maybe fast food, and the problems that the invention is designed to address. How can I get bread and peanut butter into me at the same time? Okay, and a brief summary of the invention. A piece of white bread or whole wheat bread with peanut butter in between another slice of bread. That's sufficient for the specification section if you're filing an application for a peanut butter sandwich. All right, brief description or figures or drawings. Again, like I said, I'm not much of an artist. I would always get somebody that has an ability to do renderings or mechanical drawings, to draw a piece of bread and draw peanut butter and show the, and have little arrows pointing to where the peanut butter is and where the bread is. Again, something that describes for the patent examiner exactly what it is that you have in mind. And they don't have to be really detailed, but in the preliminary patent application, I think it's essential to have some sort of drawing. Remember, in the old days, what you used to have to do is include an example of your invention. That's why the USPTO's offices in Maryland have thousands of these things, because until they changed the law, everybody had to send in an example of their invention. Think of this as a substitute for the requirement that you send in the actual thing. And then, like I said, a detailed description of the invention, describe in detail exactly how to make and use the invention in complete detail. The more detail, the better. And you can include references to various citations. Remember the high five machine that I was describing, and the one with the boots on the wheel, and the one with the dog ear protector? Those are examples of the types of figures that accompany not only final patent applications, but provisionals. Who is that? The French fellow, a picture is worth 10,000 words, and it really is. Okay. The specification, to my way of thinking, should also include a claims section and an abstract section. Now, I just want to make sure, in case you're Googling every word I say, and if you're on the USPTO website right now, you'll see that a claims section and an abstract section is not required of a provisional patent application, but my advice is to always include them for the reasons I've mentioned. It helps the examiner, and it gets you a leg up on the process of filing the final. Because remember, as soon as you file this thing, you have 365 days in order to file your final. So the more work you can get into, the more work you can front load into this process, the better off you'll be. So what do I mean by a claims section? See, I thought about this, a word about claims. All right. A non-provisional patent application should contain at least one claim. The claim or claims section must begin on a separate sheet of paper. And they're very, very particular at the United States Patent Office about these things. But again, it's not really a hard rule to follow. You have to have the claims on a separate sheet of paper. So you have your cover sheet, you have your description on one page, you have your figures on another page or pages with references back to the description. So the description can say a sandwich consists of 2 pieces of bread, see figure 1. A peanut butter sandwich will have peanut butter between the 2 slices of bread, see figure 2. This is literally how it's done. If there are several claims, they should be numbered consecutively. By the way, Arabic numerals are required by the U.S. Patent and Trademark Office. I thought I'll save you a lot of trouble and let you know that. With the least restrictive claim presented as claim number 1. So think about it, the peanut butter sandwich. Claim number 1, a piece of bread between, a peanut butter between 2 pieces of bread. Claim number 2, peanut butter and marshmallow fluff between 2 pieces of bread. Claim number 3, 2 pieces of bread with jelly, marshmallow, and peanut butter between 2 pieces of bread. The more complicated it gets, the further down in the claim chain it goes. Yes, Brian?
I know it's just an example, but how would you distinguish if you wanted to use that as a trade secret, as your secret sauce, if you're inventing a recipe?
Well, recipes are generally not copyrightable, okay? And a recipe would not be eligible for patent protection. A recipe like the formula for Coca-Cola, there are 2 things you have to do. You have to use it commercially, and you can't tell anybody about it. That's why they keep it in a vault in Atlanta. But if they were to decide to apply for patent protection, well, they'd have to make the recipe public, okay? And it would probably be rejected because it's probably mostly water, sugar, corn syrup or sugar, and a few other ingredients. So that's the kind of thing, like for instance, on Friday we have blueberry muffins from Flour Bakery. But you can go to the frozen food section of Star Market and find blueberry muffins there. Why? Because the recipe for blueberry muffins is not patentable, you can't copyright it, because recipes consist of a combination of ingredients which are in the public domain. And so, putting them together is not considered sufficient novelty in order to qualify. Some exceptions, if you put the ingredients together in a certain way that improves shelf life, that could be patentable. But generally, recipes are not. So recipes are generally not something that qualify for intellectual property protection. And that's why we can go almost anywhere and buy a blueberry muffin. Imagine owning the patent on the blueberry muffin.
If I want to play devil's advocate and make an analogy to composition of a metallurgical alloy.
Yeah.
So there's really no difference between a metallurgical alloy recipe and a food recipe of the application.
Well, the process, okay, could be very unique. You can't patent carbon and iron, right? Blueberries and shortening. But the process by which you are able to combine these in order to yield a certain result, and when it comes to materials, like with blueberry muffins, if you can show that you can improve the shelf life of a blueberry muffin, or if you can produce a purer steel, then by rearranging the carbon atoms, that process would be patentable. okay, even though everybody has carbon and everybody has iron. Does that answer it? Okay.
So let's say you have 10 claims in the preliminary.
You can think of more ways of eating a peanut butter sandwich than I can, but
You
okay.
decided I'm not going to put the peanut butter and lettuce one in the final patent. Is that you can just line it out, or it has to stay in because you put it in the provision?
No, you can change it in any way you want. I don't know why you'd want to restrict yourself in that way, because I'd want to own the rights to
Just saying, if you claim
lettuce in there too.
this thing's going to do something, and you thought, gee, I just couldn't get it to do that thing.
Well, that's why you'd leave it out. But of course, again, a strategic decision. Maybe, you're doing research and you think you may be able to get that lettuce in there. This is what the people at the University of California at Berkeley were thinking when it came to the CRISPR gene editing techniques. They overshot, and ultimately, it cost them. But sometimes it's not a bad idea to try.
And it is that, going back to metallurgy, you start from a steel that exists, and you simply find another process to get a product that already exists and is produced through another way.
Yes.
Is your new process patentable?
Absolutely, and we're getting. I gotta tell the story of graphene pretty soon because it answers all of these. But the answer is absolutely yes. One of the things about gene editing is that while these two patent holders fight it out, there are people in universities all over the world who are thinking of end arounds. Okay, so they don't have to license their technique. They're looking at bacteria for new ways of gene editing. And bacteria have millions of ways. So all we have to do is learn them. And it's no different for creating something like steel. Okay. Claims. Every word is important. The meaning of every term used in any claim should be apparent from the descriptive portion of the application. And by the way, the fee that the USPTO charges is based upon the number of claims that you make. That's one thing you may take into consideration when deciding how many claims you want to include in your provisional. Okay. Actually drafting the claim section. Okay, we have a blank sheet of paper. We're going to draft our claim section. What you should do, in my view, is begin it with the words, what I claim my invention is, or we claim our invention can do this. And as I said, one or more claims may be presented in dependent forms. All dependent claims should be grouped together, depending upon their complexity, and each claim should be a single sentence. This is not complex stuff. In fact, really what it does is require you to sit down and think very carefully about the invention that you're trying to describe. Keep it simple is the best formula for successful patent writing, claims, especially section writing, when it comes to provisional final applications. So in drafting the claim section, first include a claim that defines your invention in the broadest terms. 2 pieces of bread with peanut butter in between, or with some filling in between. That's an even broader. Okay, so instead of patenting the peanut butter sandwich, we're patenting the sandwich. Okay, so 2 pieces of bread. It can be any kind of bread, and the filling can be anything. Second, include another claim that defines your invention with as much specificity and with every option you can think of. It does not matter that the claim won't be in perfect format, with appropriate being defined as the format that the U.S. Patent and Trademark Office requires. So as you start with the general, work down to specifics, and each a 1-sentence description of what your invention can do. At the initial filing stage, what matters most is that the claims are present and that they have appropriate scope. One of the things you don't want to do is overstate the scope of the invention, because that could cause your invention to be rejected. by starting to write these two claims, you will, so in the initial filing stage, you want, as you talked about, a broad one and as many specifics as you possibly can, because that bookends your invention, meaning you've disclosed the very broad generic version of your invention, as well as the highly specified version of your invention. You want to cover as many applications as possible when it comes to your claims. When writing a claim, it's important to describe how the various components are structured and how the various components interact and connect. Two pieces of bread that come in physical contact with some type of filling. Okay? It's necessary to describe the invention so that it's complete, so that it works. Okay? Remember, operability is terribly important. And so that the claims examiner, when he or she is looking at your invention and the prior art, can see that there's been distance created by you between your invention and the prior art. Think of this as basically an opportunity to sit down with a patent examiner and describe for them why your invention deserves patent protection. And this is why we went through all the requirements of the statute for patentability. It has to be new, it has to be useful, it has to be operative. It can't be obvious, it must be non-obvious. All of those things are what you want to convey when you're describing your invention to the patent examiner. What does your invention do? This is a better mousetrap. This is a better flycatcher. Describe what the utility is so that the examiner understands the point. All right, this is a claims template. I mean, if you really want to get down on a granular level and you want to actually, if you're going to go back now and file a patent application, this is what you this is the template for a claim section. You know, I or we claim that, and then whatever it is, flycatcher comprising of whatever the parts are, will catch flies better than previous flycatchers, and describe why. Here's a claim I wrote for a peanut butter and jelly sandwich. What I claim my invention is a sandwich comprising 2 pieces of bread, peanut butter, and jelly, wherein the peanut butter is spread on one piece of bread and the jelly is spread on the other piece of bread, and then the 2 pieces of bread are put together so that the peanut butter and jelly are touching. That describes a peanut butter and jelly sandwich. That's the way you need to describe your invention in your patent application. I mean, it's a stupid example, but it's really an example of how you describe your invention in the claim, in the specification section, in the claim section. Here's claim 2. All right, we already handled the peanut butter and jelly, so now we're going to add the lettuce, tomato, mayonnaise, or whatever else that you want to include. These are dependent claims, more complex, so they come in after the first claim. Here's an actual claim of the shovel. A shovel comprising an elongated handle and a shovel head, wherein said shovel head is attached to said elongated handle. Can't get any simpler than that. That's how a claim section is written for a shovel. Last thing I want to cover is abstracts. The abstract is a short technical summary of your invention. No abstract, no provisional patent approval. So those of you who have written articles, dissertations, and theses know what an abstract section is. It's a short, concise description of your invention, and it needs to be a certain length. It can't be too long. It's like Goldilocks. It can't be too long. It can't be too short. Certainly no longer than 150 words. And it points out what is new in the art to which your invention pertains. How is it that we've created distance between this invention and the prior art? There are a lot of requirements for an abstract section. They're contained in these regulations, and if you want to really get into the granular level of this, you just need to go to the materials I'll post online. Here's the reasons why abstracts are commonly rejected. The abstract is not on a sheet of paper. They're really anal about the rules at the USPTO, so your abstract has to be on a separate sheet of paper. Talk about elevation of form over substance. The abstract is too long, too short, the Goldilocks rule. The abstract includes improper language, like legal languages like said and whereas. You want to keep any of that out of there. You just want to describe what your invention does in plain language. The abstract is non-narrative or non-descriptive, or the abstract is more than one paragraph, in which case it's not an abstract. You know, an abstract is short and concise. Remember, the content of an abstract should enable the reader, regardless of their degree of sophistication or knowledge, to determine quickly whether or not there is a need to consult the full patent text. Okay? So it should describe it in enough detail so that someone of ordinary intelligence has a general idea of what your invention does. And that's all there is to a preliminary patent application. You all know how to do one now, and you even have the templates for writing your own. So that's it for today, unless there are some questions.
So the website, you just go
www.uspto.gov. It's, you know what I'll do is next time we'll take a tour of the USPTO website, because honestly, if I can understand it, anybody can get it. It takes about 5 minutes to become an expert. It's all written so that any inventor, regardless of their level of sophistication, can get intellectual property protection. It's one of the great things that our government does. You know, and again, it's all about disseminating knowledge and, you know, creating opportunities for inventors. It really is a wonderful, you know, the best place to go is the USPTO website. Higher up the food chain you get after that, including the Supreme Court, the less they know. But the people at the USPTO, you can get someone on the phone, you can say, you know, this is my problem, what should I do, you know, how do I file this? They're very, very helpful there. The whole place is designed to help inventors. It's not a place to be afraid of, okay? So tomorrow will be our last Friday class. Free flour pastries, and we'll get into, maybe tomorrow I'll tell you the story of graphene. You know, I'll think about it. Any questions? We're cool? See you tomorrow. Thank you.
Has anyone ever tried